or if another eligible family member lives there, that's too complicated for tonight, but the spouse lives there, will not count. No more than $5,000 in life or burial insurance combined, face value. A car, and it's usually no more than $4,500 in value, but it can be unlimited if it's used to take you places. So as long as you're still using it, it can have an unlimited value. Those are examples of things that are going to be considered exempt. Medicaid's not going to count those when they figure out whether you're asset eligible. Okay, yes?
But isn't it true that if the spouse is in the home, once the spouse deceases, the property has to be sold and money given to Medicaid?
Yes. Under some circumstances, but yes. There are ways around that, but yes. If you don't do anything, yes. So, we have to be income and asset eligible. So what happens to the poor spouse who's at home, who all of a sudden is not allowed to have more than $2,000 in assets? Well, let me step back. What about that family that has $102,000 in countable assets? They have $100,000 in the bank. They're going to have to spend down $100,000 in order to qualify. Now, in the process of spending down, they have to get equivalent value. They can't give any of it away. They have to buy $100,000 worth of goods or services that will not result in more countable assets. So if I go out and spend $100,000 on land, now I have a $100,000 piece of land that's going to count. So that didn't help me any. So what they're intending is that you pay for the nursing home, 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 until you get down to just the $2,000, and then you reapply. So where this gets complicated is when we have a spouse. Because the spouse is protected in two ways. The spouse is protected from impoverishment by being able to protect 50% of countable assets up to $109,560. Okay? The spouse also gets enough income from both her own income or his own income and his spouse's in the nursing home to make $1,823 per month. That is what the spouse gets to protect. And so if you have a couple that has $220,000 in countable assets, and one of the two individuals is in the nursing home, if you're a lawyer, you tell them, apply today, apply right now, apply today, because right now your spouse can protect this maximum amount. If they wait until they only have $200,000 in the countable assets, they pay the nursing home for 4 or 5 months and then they apply, now the spouse only gets to protect $100,000.
I'll get you another marker.
I got good. In assets. Because she only gets to keep half. It doesn't matter how much it is, it's only half. Up to this maximum amount. So by waiting until they got down to $200,000, she just lost $10,000. Because half of that money they spent was her money that she could have protected. But she didn't apply when she could protect this maximum amount of money. So the irony of Medicaid is that when an individual applies for Medicaid and their spouse is in the nursing home and they're applying for their spouse, many of our clients who live at home actually see an improvement in their standard of living. Because they're still getting income from their spouses in the nursing home, and now they have no more medical expenses related to that person. They have no more food expenses related to that person, no more transportation expenses related to that person. All of a sudden, and some of my clients feel guilty about this, all of a sudden they have more money than they had before. So it's ironic. Now, the last thing I'm going to say, and then I'll open the floor for questions, is the other really complicated part of this Medicaid process is the look-back period. The reason why we don't encourage people to transfer a property from a parent to a child is because a lot of the time that property would be exempt if it hadn't been transferred because there's a spouse living in it. But when they transferred it, it's now going to result in a penalty. Because now Medicaid is going to look back 5 years from the date of application to see if you've given anything away that you could have used for nursing home care. So let's say that you apply November 15th, 2011 for Medicaid. And on July 6th, 2009, you gave $48,000 to your grandson for college. And on 10/1/2010, you gave away your $96,000 home to your children because you didn't want the government to get it. Okay. When you apply for Medicaid on this date, they're going to look back. And they're going to look back not to 11/15/2011, but to 11/1. They look back 5 years and to the beginning of that month of eligibility. And this has caught some lawyers with their pants down, quite frankly. They made a transfer, they waited 5 years, and the day after, they applied for Medicaid. And Medicaid looked back to the beginning of the month and said, oh, you gave away a $500,000 house 5 years and 1 day ago. Oh, no, that's outside the look-back period. No, it's not, because we go to the beginning of it. That's a bad, bad day if you're a lawyer. Bad, bad day. Bad day for your lawyer's malpractice insurance carrier. So they're going to look back, and they're going to see that you gave all this away. And they're going to divide what you gave away by the cost of care. And they're going to say, look, gave away 10 months worth of care here, gave away 20 months worth of care here. We're going to disqualify you from benefits for 30 months. And this is going to start once otherwise eligible. Do you know why that is such a horrible phrase? Why is that such a horrible phrase? In other words, you've already spent all your money. You're down to your $2,000. You're otherwise eligible means you've spent all your other money down. You don't have money to pay for this 30 months. The last thing I want to say about this process is this is an example of bad public policy coming out of bad professional practice. What happened over time is that back in the day, back in 2004, whenever an individual gave away less than the cost of 1 month's care, Medicaid said, you know, no harm, no foul. It's okay. You couldn't have even bought a month's care with that. Don't worry about it. We're not going to penalize you for that. And so what astute elder law attorneys did was they advised their clients who knew they needed nursing home care in the future to give away $3,000 every month. So every month they gave away $3,000. So over the course of a year they gave away $36,000. But when they applied for Medicaid, no penalty, because they never gave away in any given month the cost of care for 1 month. And then they said, okay, well, we're now going to aggregate these things, but if in 2 consecutive months you give away money, we're going to add them together. And so they said, okay. They gave away $3,000 1 month. The next month, don't give anything away. The next month, they gave away $3,000. Next month, don't give anything away. And they spaced out those gifts so there would never be an aggregated transfer penalty. So then Medicaid said, okay, well, and what the other thing that Medicaid would do is they would allow the penalty to run the month after you made the transfer. And that made good public policy sense. Because if you had the money in January of 2004, you could have bought long-term care in February of 2004. But in March of 2004, we don't really know whether you would have had that money or not. And so Medicaid would say the penalty for giving that money away will run the next month. And so lawyers would give away a month's care every month, and that penalty would run the next month. A month's care, they give $4,800 away this month, the penalty would run the next month. They give $4,800 away this month, the penalty would run the next month. The penalty always ran, right? And so what lawyers would often do is they would engage in what's called half a loaf planning. They would say, look, you have $96,000. You're not allowed to have more than $2,000 and be eligible for Medicaid. So let's do this. Let's give your child $48,000, okay? And you keep $48,000, and you apply for Medicaid tomorrow. And Medicaid would say, okay, you gave away $48,000. That's 10 months worth of care. We'll penalize you starting today for 10 months. And they would say, well, I have $48,000. I'll just pay out for 10 months. And at the end of 10 months, they spent all their money, and they were able to give their children $48,000. And so what happened is lawyers exploited so many of these loopholes that the final measure that we got is unbelievably draconian. So the law that passed, the DRA, Deficit Reduction Act of 2006, when it passed, they said, you know what, we're done playing games. We're going to look back, and during that look-back period, we're going to aggregate every single gift you made to anybody, regardless of the amount, and we're not going to allow that penalty to run until you've exhausted all of your other resources and you're otherwise qualified. And so the result of this, though, is that now, whenever there is any unexplained expenditure of more than $100, Medicaid treats that as a transfer. And now these little things, $100 ATM withdrawal that can't be explained, they're all aggregated as part of a transfer penalty. And by law, Medicaid is allowed to presume that that was a gift to somebody made for purposes of qualifying for Medicaid. The end result? All kinds of things. Gifts to grandchildren for college. We even had a case in North Alabama where a tithe to a church was counted as a transfer. Now, when they proposed this law and there was public comment, I wrote all of our congressional delegation. I said, you understand what's going to happen. You understand that the way the law is written, a common tithe to a church is a gift, is a transfer that is subject to a penalty under the Medicaid law. Oh, no, that's not what we intended. Well, guess what? We just had our first case. And they said, a gift to a church's building fund, that's a transfer subject to a penalty. So you can see that our choices in professional practice can lead to bad policy. And I'm hopeful that at some point there will be some rollback from where we are now back to something more reasonable, something closer to what we had before. There's better policy out there, and policy that encourages people still to save, because right now there's no encouragement to save. To protect you later on from a lot of the things we've talked about today, but I think it also serves an important role in the family unit to have these discussions. Where is it that you want to live? How is it that you want to age? Where do you want to be? When you buy a long-term care insurance policy, you hope that it has graduated benefits so that if you want to stay in your home, you're still going to get a benefit. They're going to pay for at-home care so you can stay in your home. You know, and so you need to have these conversations with family, not just as a matter of planning, not just as a matter of getting these documents in place, but making sure everybody knows what it is you want. Because there may come a time where you can't communicate that anymore. And people need to be able to say, you know what, we had that meeting with mom and dad, and they said they really would rather stay in the home, even if we had to use all their assets to do it. They would really rather stay at home and have in-home care. And they told us, don't assume that they don't know where they are, because they probably do. We don't understand a lot of these illnesses. We don't really understand what they know, what they're aware of. You know, and so if you communicate clearly to your children, you know, at all costs, I want to age here in my home, then you hope that's going to be respected. And you should appoint people who are going to respect that, who are going to manage your finances under a durable power of attorney in a way that allows you to stay there. And individuals who aren't going to use their health care power of attorney to place you in a facility when you reach the point where you no longer have the capacity to object. Yes?
Do you recommend that people identify in their wills assets that they want to go to specific people or places?
Absolutely. The more specific a will is, the better it is. And I'll also mention something that Professor Parker and I have talked about several times, which is a will doesn't have to be just about property. I mean, there can be other things in a will. You can express your wishes about how you want family members to